Reading 2.3 by Lane et al. Takes a look at agenda setting on the United States Supreme Court. This article leverages an interesting mechanism by the United States Supreme Court known as discretionary jurisdiction. This process of discretionary jurisdiction allows the United States Supreme Court to decide what cases it wishes to hear in the majority, overwhelming majority of its caseload. And so not only does it go through exceedingly well explaining the process of agenda setting, it actually looks at quite specifically what are some statistical predictors that increase the likelihood that the United States Supreme Court will grant certiorari and ultimately hear your case. A few things. Many courts of last resort, the United States Supreme Court as a court of last resort and state Supreme Courts as courts of last resort, have at least part of their docket determined by discretionary jurisdiction. That simply meaning they get to choose what cases they wish to hear. Now, a significant amount of research has gone into looking at what affects the likelihood the United States Supreme Court will hear your case. We know that the overwhelming majority, sometimes over 95% of the cases that are appealed to the United States Supreme Court will not be heard. Only a small number of the thousands of cases will actually be scheduled for Supreme Court oral argument. And there is one really good reason for this. The Supreme Court will not take cases in which the area of law is settled. And what this means is, even if a lower court, a lower federal appellate court, gets a decision wrong, legally wrong, the United States Supreme Court does not have an obligation. In fact, it would be want to do so in terms of stepping in, because the United States Supreme Court is not what we consider an error correction court. The court does not exist to correct problems of the lower court. The court exists to make sure that law is systematically and equally applied across the United States. So if one court gets it wrong, one court, let's say, remember from last week, let's say one court in the Fifth Circuit makes a decision incorrectly, but all of the other three judge panels in the Fifth Circuit are making the decision consistent with United States precedent, and there exists no other disagreement among any of the other circuits. The Supreme Court simply won't hear that case because there's no need to correct an error that's only an N of one, there's only one example of. So the Supreme Court, when we look at what will affect the likelihood that it'll grant certiorari if it will decide to hear your case, there are a litany of things that actually predict whether or not the Supreme Court will hear your case. And when I say predict, I don't mean sort of a one-to-one sense that if you have this variable, the Supreme Court will hear your case. All I simply mean is that the likelihood that that case will be heard will actually go up. So one of the things that we know actually will increase the likelihood that the Supreme Court will hear your case is if there actually exists a conflict among the circuits. So what this means is that two circuits are deciding a piece of law in different ways. So in function, that means that, let's say, for example, the law in the Fifth Circuit is being enforced differently from the law in the Eighth Circuit. And that disagreement between the circuits does trigger the likelihood that the Supreme Court has to step in and fix that, because they want to make sure that the precedent is uniform across the board. Another factor that increases the likelihood that the Supreme Court will hear a given case is if the U.S. is actually party to that case, or if the U.S. supports or opposes the Supreme Court hearing that case. So if the United States is party to a case, that increases the likelihood that the Supreme Court will hear it. But if the United States as an amicus supports the Supreme Court hearing a case, they're more likely to do so. And if the United States opposes the Supreme Court hearing a case, they're less likely to do so. Though So the mechanism of the Solicitor General here, the Solicitor General being the attorney for the United States government, that individual has a pretty significant degree of sway with convincing the U.S. Supreme Court whether or not to hear a case. Another thing that actually increases the likelihood that the Supreme Court hear a case is if the appellate court, so the court that it is being appealed from, reverse the decision of the actual trial court. So let's say the federal trial court ruled in one direction and the appellate court reversed the lower court's decision. That triggers an increased likelihood that the United States Supreme Court will hear that case. Furthermore, if the appellate court declared a federal law unconstitutional, that triggers a heightened likelihood that the Supreme Court will hear that case. The last two things that the article focuses on is amicus briefs. And I want to put this in some more context, or at least give an idea of what Lane et al. Are looking at here. Lane et al. Are simply counting the number of briefs that are urging the Supreme Court to hear the case or urging the Supreme Court not to hear the case. Now, it turns out this has been a consistent finding across a wide variety of appellate courts and has been replicated on the United States Supreme Court numerous times. And that is, the number of briefs is what is important, not necessarily what they are urging the court to do. So a large number of briefs urging the United States Supreme Court not to hear the case actually increases the likelihood that the United States Supreme Court will hear the case. So there's no directionality issue here. There's no, it's not effective. In fact, submitting the Supreme Court a brief urging them not to hear a case actually has the inverse effect than the individual submitting the brief would have hoped, and that it increases the likelihood the Supreme Court will do the opposite of what the brief urged. So this interplay, it's an interesting step before the Supreme Court rules on the merits. And that's why we call it the agenda setting stage, is because the Supreme Court is deciding what cases it's going to hear during its term. So it's setting its own agenda. And this is one of the areas for the United States Supreme Court that's studied extensively beyond decision making, which is also studied extensively, but which doesn't play out as neatly based on ideological cues as we find in decisions on the merits. So when the Supreme Court is making a decision in the case, we find that ideological cues overwhelm the process there, and that it's the strongest variable in the model. But when we look at decisions to grant certiorari, ideology, while it plays a role, it takes a back seat to actual legal variables. And so the Supreme Court is fairly disciplined in terms of what cases it takes, dependent upon the legal environment in which it's considering the case, which goes to show that despite many of the claims that the United States Supreme Court is not a legal body, we know that to a fair degree, at least the agenda setting stage is affected by legal variables.